very good afternoon to all you who are passionate about contract law. I was sharing with Dr. Mei Cheong that without passion, we can do nothing. Passion is something that drives us. Passion could be different kinds of passion, and the passion of our mind and our interest in the subject matter can generate interesting ideas. This is the goal of our webinar. It is not an end in itself. It is an exploratory dynamic whereby both local Malaysian academics and overseas from the Commonwealth, which we have welcomed, share their commitment to understanding an area of contract law which interests them very much so. I think that is something that encourages all of us. My own personal journey in contract law started over 30 years ago when I first taught it as a young tutor and inflicting my pain upon people like Dr. Mei Cheong and Usha Rani, who now they forgive me for some reason and are willingly allowing themselves to be tortured by invited to take part in our seminars. For that, I am grateful that they have forgiven me. But today, we are very interested to know that we have three major topics. They seem disparate, but as of yesterday, when we listened to the presentation on minority, we realized how much contract law is related to each other. And even when we put a lens on one single topic that seems apparently not very exciting, can actually lead to wider reflections about contract law, legal transplantation, contextualization, and contemporary challenges. So today, we're going to have a very interesting evening indeed. We start off our Premier League football match on this by inviting our first presenter, Dr. Usharani Balasingham, whom I have the privilege of renewing my friendship after many years of hiatus. And looking at her biodata, you can see that her journey has been an interesting one. She has gone to the private sector, practiced there. She has taught law. She had taken part in commercial transactions, and he is vitally interested. She is vitally interested as a law teacher and a researcher. From what I hear from her conversations, she cares very much for her students and also for the thesis writers whom she supervised. To me, that is the singular contribution of all academic staff, teaching, researching, and sharing. Dr. Usharani today will share with us her findings and analysis of a topic whom in my young life undergraduate, I actually wrote a short essay on, of course, lost forever now, thank goodness, on jus quasitum tertio, a great Latin word which I saw Dr. Usha in her PowerPoint referred to. I will ask her to unpack that. So for those of you who never thought, what is jus quasitum tertio? Hang on to your boots and listen and lend her your ears. Over to you, Dr. Usharani.
All right. Hello, everyone. Thank you, Prof. Philip. You do me great honor, but actually I'm a very simple person, right? Right. I would just like to thank Prof. Philip for all his effort in organizing many seminars for this faculty. I mean, he's brought the faculty great glory, and he has pushed for reforms. He has really stretched us, but it's a good agenda, and it's very needed. So we are very grateful to Prof. Philip for all his endeavors for the faculty. So today, actually, I also would like to thank all the guests here, and I think a lot of them will be students. So the first 10 slides actually are meant as an introduction for the students, for them to understand the concept of privity and the difference between the Malaysian and the UK concept. Then we'll get into a little bit on the meaty stuff. So it's divided into Contracts Act, Introduction and Features, Privity, the English and Malaysian position. We will look into some case law exceptions, and we'll see how, even within the case law exceptions, even though we come under certain categories, there is overlapping. Then we'll look at the parties' own action as to how they can avoid the rule of privity, and we'll look into some statutory exceptions that exist. And finally, other jurisdictions have basically taken the step forward into enacting certain legislations, and we will just peek into the legislations that they have enacted for further reform should it be needed for Malaysia, which is something that we are lagging behind. So we need to look into this area of reforms. So let's carry on with the topic. Now, basically we have the Contracts Act. The word is contracts, yeah, with an S. And it covers general doctrines relating to contract law. It has been applicable throughout Malaysia since 1st July 1974. Now, this is the interesting part. The moment is not a code. And I remember Mr. Ong Chee Koon's comment that he wanted to have a code. I think first we have to unpack the word code and what do we mean by code. If you look at the National Land Code, it's supposed to be an exhaustive document. But it's my view, my own view, that it's not possible in contract law to basically have a code because of the fact that it's not just rules, but also equity that basically factors into development of law. And we will see that basically in contracts and some other areas of law, it's not everything that's within the Contracts Act. For example, we don't have concept of invitation to treat, a counter offer. We don't have concept of implied terms. We don't have concept of intent. And I still remember Prof. Philip's lecture on fundamental breach. Yeah, the Hong Kong fur case. So all these concepts are concepts that are common law, right? And it's vast, yeah? So the area of wanting to codify these vast areas, and which is continuously developing, even the concept of conscionability is also another area, estoppel, right? So we have many areas that are developing, and I wonder when he referred to the lady who proposed codification, and inverted for commas, the word codification carries a different meaning to me. It doesn't mean an act. I don't know what it means in UK, whether it means an act or a code, you know. An act, we can see, like in the Current Contracts Act, it's just described as an act relating to contract. It is not a consolidating or amending statute, right? It's planning to codify, the word here codify, but it's not exhaustive. Law of contracts regarding certain aspects of law in certain areas within certain sections, right? It's modeled on the Indian Contracts Act. And we can see that there's another provision here, section 1, subsection 2, that says that the common law will continue to apply unless some different legal consequences are spelled out in the Act. Now, bear in mind that Singapore and even UK don't have a Contracts Act. And I'm sure Singapore has a reason why they don't have it. So let's look at the section that I mentioned just now. Oh, sorry. All right, I wanted to actually highlight this. Yeah, if you can look at 1 subsection 2, it says nothing herein contained shall affect any written law, any usage or custom of trade, or any incident of any contract not inconsistent with this act. Right. So the next point is that English law is persuasive. So we do find our local cases also looking into developments relating to illegality. We have basically the Limpotan Symphony's case that followed the Patel and Mirza, you know, and I think it's a reaction to current dilemma in societies these days. How do we define illegality and whether we want the person to benefit from an illegal contract? So we find basically changes happening based on reaction to societal situations. Yeah. So, and that can happen because of the flexibility that's given to the courts interpreting provisions within the Contracts Act even. So we do have that, and also we have the case of CMB Anthony Burke. I mean, we have developments where we're looking at provisions within the Contracts Act as opposed to uncoded or unwritten rules that is actually existing side by side within the with the Act. So we do have, however, another provision that basically provides that if there's an express provision under contract, it will prevail, right? So we do have a case here, the case of Yusof Bong Nyong and Ho Kim Hui, where the provision relating to release of security sureties are different from common law. So 1968 case, yeah, where basically the court basically said that the express terms in the Contracts Act will prevail over common law principles which are at variance, yeah, with it. So we do have this issue whether a release of a co-surety would release the other surety. Contrary provision is provided for under Section 91 of the Contracts Act here. Yeah, so that will apply. Then we have and the concept of privity here is actually conceptualized in the case of Dunlop Tire and Sepfridge and Company, which was also referred to in Ponshaw's yesterday's session. And this case, basically, we're talking about situation where who can sue under the contract. So you do have a situation where Dunlop sold tires to Dewey and Company, and with an undertaking that it will not be sold under the listed price of Dunlop. And Dewey here sold tires to Sepfridge, who sold below the listed price. And there was an undertaking there, you know, not to sell below the listed price. And the question now is whether Dunlop can enforce the undertaking against Sepfridge, which is a third party. Yeah? Dunlop is not a party to the contract. So here we have the statement in the case of the judge's statement here, which I have highlighted the relevant portions. I don't plan to read out passages for you, so I've highlighted it so that you can read it on your own. So the only point is that only a party to the contract can sue, and that party must have provided consideration unless the contract is under seal. Now the doctrine has basically two aspects, basically prevention of third parties from obtaining benefits and preventing parties to impose obligation on third parties, right? So that's basically the effect of it. And in UK, basically the doctrine has been tempered by the introduction of Contracts Rights of Third Parties Act, which is 1999. Now in Malaysia, we do have a certain provision that was contended to depart from the privity rule, but it didn't succeed. The contention didn't succeed. This is actually the famous case of Kapong. So in this case, the court actually referred to Section 2D, where the consideration was stated that it could proceed from the promisee or any other person. But in the case, the Privy Council rejected the argument that a third, this is where Prof. Philip has mentioned principle of just causadium tereo, yeah, to allow a third party to sue in a contract where he's not party to get a benefit. So in this particular case, it means a right vested in or acquired by a third person arising by way of contract. So in this case here, in Kapong, the party actually here, Smith, entered into an agreement with Kapong. Basically, he was supposed to pay himself a certain commission for obtaining the prospecting permit for Mr. Tan. And in this case, he contracted on behalf of Mr. Tan, and he couldn't enforce the contract because he was not party to it. So this is the case judgment from the case where Lord Wilberforce basically observed, yeah, that despite the provision of Article 2, subsection D, it does not detract from the doctrine of privity that only a party to the contract can sue, right? So that's the Kapong case that we are bound by. And a more recent case that would adopt the privity rule is the case of the Naga National Berhad and Restaurant Al Ibrahim Maju, right? So the question is whether a tenant could mount an action for electricity supply to a premise that was registered in the name of a landlord. The answer is he could not because of the rule of privity. And this case, I would just want to highlight the findings of the judgment, which we'll be coming back to this case later. This case of Rasha Enterprise and our Finance Berhad, we have the Justice Abdul Malik Shah, the Court of Appeal, basically said that Kapong prospecting gives gloom picture that doctrine still applies in Malaysia. So, we have the doctrine of privity applying in Malaysia. So that's a brief for the students out there. Yeah. So now we're going to look at the issue of construction of how the courts have construed and circumvent the doctrine of privity in cases. Yeah. And I would say there's an overlap, but the courts have gone into this in either using agency, collateral contracts, implied contracts, trust, estoppel, restrictive covenants, and also the law of succession. So we will just quickly go by this. So this is the recent case. This case actually, you have a situation of a land fraud, right? We have two brothers whose land were transferred to Heva Plus fraudulently, and Heva Plus to finance the purchase of the land from the people who defrauded, entered into a loan agreement, and a charge that was created by the UOB Bank over the property, right? And then subsequently, Heva Plus decided to sell the property again to Kam Hui, and Kam Hui also took a loan from Public Bank, and there was exchange between the UOB Bank and the PBB Public Bank, where UOB Bank gave a redemption statement and an undertaking to refund the redemption sum to PBB if the discharge of the UOB charges were not registered for any reasons attributable to UOB. So in this case, what happened is when the brothers basically found out about the fraud, they took action. They lodged a registered caveat, and the transaction between Kam Hui and also the charges couldn't go through. And Kam Hui then, in this action, among others, claim against UOB, who's the seller's Heva's financiers, for breach of the undertaking to refund the redemption sum. The undertaking was given to the bank, the buyer's financier. So the question then is, can Kam Hui claim on an undertaking that was given to his financier and not himself? Yeah. So in this particular case, yeah, the court held that the court used a Mantley and Wheatley principle of construing contemporaneous documents, and in this case found that the sale or purchase agreement and the loan agreement was so interlinked that one would not have existed without the other. And in this case also, the court held that the Public Bank was nothing but a conduit for payment for the redemption amount, and basically was acting on the concept of an agency situation. Now, this case again appeared in 2021 in a related case. Then this time, the federal court there, Federal Court Judge Bernard Wong, basically mentioned again this concept that the loan agreement and the finance agreement couldn't stand alone, and it was money that belongs to Kam Hui that PBB was actually given to the UOB. So it was a case of where they could interfere and sue UOB for the breach of the undertaking. Yeah, so this is the two cases that are related. Now I'm quoting this case also for agency, but this case is on the flip side. This case is where a proof of debt was lodged, but in this case, the court basically held that the debtor did not act, was acting as an agent, was not for third parties who were the principals, and this was the appellant here knew about it, so his proof of debt was rejected. So this is where the party that you're contracting is an agent instead of a principal, and you can't buy. So in this case, it's a flip of that. So the other case that I would like to refer to here, this is for the point of ratification. Under the Old Companies Act, Section 35, we allow the statutory provisions allow for ratification of an entity that does not exist at the time that it rectifies the contract. This is a statutory rule which overrides the common law rule, so that for agency situations, for cases of companies incorporated under the Companies Act, where Section 35, or the now, in this case, in 2016, Section 65, we have situations where you can rectify, a principal can rectify a contract, here the principal being a company, even when the principal is non-existent at the time of the contract. So this is for that principle. Now, the next, collateral contract. Now, how do the courts treat this argument of collateral contracts? So basically, the collateral contracts are viewed suspiciously because it seems to be avoiding the parallel evidence rule or trying to insert terms additionally, right? So basically, the courts will basically look at the facts of the case and decide whether there is a collateral contract or not. So, but it provides an exception to the rule of privity. When the courts find that there is a collateral contract, then the court will allow for the exception to the rule of the privity. In that case itself, it didn't succeed because the court did not find that there was, on the facts, a collateral agreement to vary the terms, interest rates. But in these two cases that I'm showing you right now, you have the case of Shanklin Pier and Bank Pembangunan Malaysia and Spring Hill. In Shanklin Pier's case, we do have an issue of a warranty. Yeah. So I think this case, most of you who have already done contract law would know this case. Yeah. The Shanklin employed contractors to paint the pier, and he had the right to specify what paint to be used. And the seller of the paint, Detel, represented to Shanklin that the paint was suitable for painting the pier and 2 coats would last for 7 years. And he then instructed the contractor to purchase the paint from Detel. And however, the paint peeled in 3 months. So he sued for compensation. And here the court found there was a collateral contract. Detel had made a warranty, and there was elements that was fulfilled, like it would be in a normal contract. So he could sue based on a collateral contract. Similarly, in the case of Bank Pembangunan Malaysia, the case, basically, the court held that hang on a minute. A contract of guarantee, yeah, is essentially a collateral contract. And this is cited in this case, but I would like to go back to the case of Rafasha Enterprise and Arab Malaysian Bank, also on the same point, right? In this case, we have an application to strike out the defendant's counterclaim. A defendant here guaranteed a loan that was given to the borrower, yeah, under a loan agreement by way of charge over the defendant's property. There was a default, and the defendant was sued. And the defendant raised a counterclaim where he relied on 2 letters from the borrower to the plaintiff. And the issue here was whether or not he could raise a counterclaim because he was not privy to the contract between the plaintiff and the borrower. So the court basically said that there is a tripartite relationship between the parties under the loan agreement, and he could raise the counterclaim, right? And there is the court treated it. Yeah, there's a contract, collateral contract between the defendant. The defendant guarantor here has certainly the necessary locus to file the counterclaim based on the 2 letters against the plaintiff. So this is the case of. Then we have another one is implied terms, implied contracts. Yeah. So in this case, basically we have Baltic, who sued Eastern Pacific Industrial Corporation (EPC) and Condesi. And when in his suit, the argument was that Baltic did not have a privity of contract with EPC and was not a subcontractor with Condesi. On the facts, however, yeah, the courts construe there was evidence of an implied contract, right? And because of the transactions between the parties, the informal joint venture relationship between Condesi and Baltic, even though the joint venture was not officially, was an informal one, not a formal one. So the court construe implied contract to allow Baltic to pursue his claims. Yeah, and in this case, we see that EPC had breached contract by offering Condesi the contract, yeah, and Condesi had breached his joint venture agreement with Baltic by accepting the offer, right? So this is another mode of allowing a third party a remedy. Now, another case on trust. Now, this case of Malaysian or Australian finance. Now, in the case of Dunlop Tire, trust was expressly mentioned as a way whereby a right can be conferred, right? And in Malaysian Australian finance and the law union and rock insurance company, we have an issue before the court was whether the applicant had rights that were extensive as the insured. So we have a hire purchase agreement. The insured, the Chong Kok King here, was instituting his own name from the loss that was the subject matter of the coverage. So the court actually covered a few grounds. The grounds that they covered were agency, estoppel, and trust. Just to make sure that, you know, that they justified rights of the plaintiff to sue. So in this case, you can see, I won't read it for you. The slides are there, where one is basically as an agent. That means the insured was acting as an agent. And the estoppel part of it is where there is the endorsement part, where there was an endorsement on the insurance policy. So that also creates an estoppel, right? And trust, where there is between the parties an understanding that a third party would benefit as a beneficiary, right? Then the third party can be allowed to insist upon and enforce the trust, the contract, right? So these are all excerpts from the judgment, which I would let you view and read faster than I can word it for you. All right. So it's just telling you how a trust can create a right on the beneficiary to sue. So this, another recent case, 2021, is just to show you how a resulting implied or constructive trust can arise. This is basically on a very clear-cut bare trustee concept, right? So this is the Court of Appeal judge, Yang Arif Lis Yu Sing, right? So the case of Nuraini, Muhammad Hadi, and Pembangunan Tanah Perumahan. Another old trust case is where you have a family trust, where evidence of monies purchased through a family fund. And here again, the court basically found there was a trust relationship, implied trust existing for third-party beneficiaries, yeah, to enforce. So you do find that as under trust. Now, under estoppel, you have the case of curve, where you have a situation of estoppel. This bearing in mind, we do have estoppel is not provided for under the Contracts Act. So I mean that's why the flexibility of the law is something that we should treasure and safeguard. So in this case, we have the first plaintiff who was the owner of the vessel, and the second plaintiff, the agent of the first plaintiff. And the second plaintiff bid for the ocean contract, and it was promised to the plaintiff but not reduced in writing. And acting on the assurance of a confirmation of contract, they proceeded to South Korea for the first shipment. Then the defendant awarded the contract to another party. The plaintiff sued for breach of contract, but the defendants say that there's no contract between them. And in this case, you find the courts construing, Justice Kamalanandan Ratnam construing the transaction between the parties based on principles enunciated in Walton Source and Bousted. He construed the transaction between the parties, and as you can see there, A, B, and C, there was basically a representation made that they will be given the contract, and they were told to get the ship ready on a certain date to be ready for the first shipment, right? And in this particular case, in fact, you find that on the 12th of September 1999, plaintiff had dispatched the vessel, and the defendant knew about it, but didn't good. He said, good, at least we can show that we can be sure that there will be no delay, right? So on the facts of the case, the court held that the defendant had all material times actively encouraged plaintiffs in the assumption that they had been awarded the ocean transportation contract. So it would be unconscionable and unjust for the defendant. Now, our Contracts Act, I must say this, has been old one, yeah, and we have not been very vigilant in updating the law. And some of the methods whereby remedies are given is by virtue of common law and equity. So unless we have a very active law reform body who are constantly looking at every angle of the law and contemplating all angles, it's very difficult to come up with a code, right? There's the other reasons I want to get to that later. But let's concentrate on this. So we do have the restrictions here. Now this is on land covenant, right? So we do have our former president, Saleh Abbas in this case, whereby this case actually concerned purchase between from a vendor of certain floors. And they were using the floors for hotel business, but the ground floor and the first floor were given. They had an access route to the rooftop, right? And this particular case here, even though the appellant here was not the party to the contract between the respondent and the vendor, but they knew of the restriction on the land relating to right of access when they bought the building. And in equity, they were bound by the notice of restriction that run with the land. So this is a restrictive covenant that was binding on the party who had notice of it. So again, here you find the courts bringing in equity. Yeah. So I have quoted the judgment for you to view. Not just my words or my interpretation, but actual judgment from the judges, right? Okay. So the next would be the case of Bestwick and Bestwick. Now, Bestwick and Bestwick is the case where you illustrate law of succession, where in this case, a coal merchant who transferred his business to his nephew, who promised him that he would pay his widow £5 a week. Uncle died, and the widow became his amixtrix. And the widow sued on her own, but she couldn't because she was not party to the contract between the uncle and the nephew. But as the amixtrix of the estate of the uncle, she could sue the nephew. But the problem in this situation, later on, we will come across, you'll find the contracting party might not be the party who suffers the loss. So this is the predicament that is that the party would face, the third party would face. The contracting party is not the one who suffers the loss, the third party suffers the loss, and the third party can't sue. So that is the issue that is underlining the difficulties of a privity doctrine. Now, action by parties. Action by parties, you can do it by two ways. This is, we know, assignment and novation. One only confers benefit. Assignment confers benefit, but novation can confer rights and obligations. Yeah, it's between the existing parties and the incoming party. So this is parties' own actions that they can take. Now, lastly, towards our ending, some statutory exceptions. Now, the statutory exceptions that exist are various. I can find some. One of it is actually the Consumer Protection Act, 1999, where you have consumer the rights to sue against manufacturer, which we also have the rights under the doctrine of negligence. We have the Bill of Exchange Act, where the endorsee there can be parties that can sue the payor, right, by virtue of endorsements. And then we have Road Transport Act, again, another situation, yeah, and Construction Industry Payment and Education Act, where Section 30 allows direct payment from principal. We have Section 23 of the Civil Law Act, where we have a statutory trust situation. I must say, in this case, the dissenting judgment of Federal Court Judge Yang Arif Muhammad Ghazali Yusof, to me, is much more attractive because I can't see how a party who doesn't have the money can become a trustee. And he also argued it on a different point. He argued that the fact that whoever is holding monies that doesn't belong to them and they don't belong to other party, they also become a constructive trustee as opposed to a statutory trust. Argument's very attractive, the dissenting judgment. But we do have statutory trust majority judgment that basically says that the policy money is held by insured or insured insured that the personal representatives for named beneficiaries. That's the majority judgment. And then we also have Section 126 of the Legal Profession Act. This is a recent case. I think it will be of interest to practitioners. So that's why I have put it in greater detail. So we do have practitioners. Okay, this case, what happened was you have a law firm who was made a third party by his former client in a civil suit. And Wong Hock Man from the firm of Azim, Tunku, Farid and Wong was appointed by the insurer to represent the respondent in the matter that was pending settlement. And the contract was between the insurer and the appellant. The consent judgment was recorded, and the appellant's bill was forwarded by the insured to the respondent before the settlement was concluded on the 2nd of February. Respondent was not happy and considered the bill to be unreasonable, exorbitant, excessive. Yeah, but the application to tax the bill was filed in 12 December 2018. That's almost a year late. So the issue in this case is that can the respondent who's not party to the contract between the insured and the appointed lawyer contest the bill? And when does the time start running for the 6-month compensation to file the action to tax the bill by the person chargeable or liable to pay the cost? So in this case, we find this is the Section 126. I put up the provision. The held is actually at para 8, right? where the court basically held by virtue of the provision of 126, where it says any person liable to pay the cost would include, the party who is contesting the bill, not just the insurer, right? So in this case, then there is a statutory circumvention of the privity rule that is in para 9, and the time frame to file the bill is from the date of delivery of the bill to the insurer, right? So the 6 months runs from that time frame. So in that case, also there was other arguments relating to whether there's extension of time, etc. But this is the Now my conclusion. There are certain comments that I've extracted from certain cases that talks about the rule of privity. And in one of it is actually the case of Razaf Shah Enterprise, Arab Malaysian Finance, where the court said that the case for recognizing, sorry, I somehow rather have the cursor being blocked, all right. The case for recognizing contract for the benefit of a third party is simple and straightforward. The autonomy of the will of the party should be respected. The law of contract should give effect to the reasonable expectation of contracting parties. The principle certainly requires that a burden not be imposed on a third party without his consent, but there is no doctrinal or logical policy reason why law should deny effectiveness to a contract for the benefit of a third party where there is the express intention of the parties. And we have an old textbook here, 1995, that also talks about the rule of privity, whether the many exceptions to the rule make it tolerable in practice, but it provoked the question of whether there is a need to modify or abolish the rule altogether. The quandary, as I mentioned earlier, is that the party who suffers the loss can't sue, and the party who might not suffer the loss can sue. So we do have that kind of situation in the situation of Bestwick and Bestwick. Now, other jurisdictions have got Contracts Act, rights of third parties. Yeah, we have it in Singapore, we have it in UK. And I just want to share with you the sections. We're not getting into this today, but just to know that it has been, the law of privity has gone ahead by way of recognizing rights of third parties in other jurisdictions. So just sharing this, I don't know whether you can view this, but to basically, okay, you can see this better. So this is the UK provision, right? Okay, so right, I think that ends my presentation. But Prof. Philip, 1 minute. I would like to say one closing statement because I'm still caught up with the codification of contract, which I find, you see, even when they actually did Companies Act, when they amended the Companies Act, and they changed the provision of section 131, was it 132 subsection 5, and the new section is section 222 of the Companies Act 2016, and the duties that were prescribed, are under the old section says duties prescribed are in addition to any written law or the rule of law. The new section 222, duty prescribed in addition to any other written law. So the rule of law was taken out, in section 1325. And I hear when we do start messing with, wanting to codify, sometimes we take out, the rule of law element, the common law element, in developing. And it was a bit surprising because when we talk about good faith under section 213 of the Companies Act, we talk about best interest. When we talk about section 213, 218, or we even within the Companies Act, breach of trust, all these are rules of law, So we mean, in fact, we need if you, the point is that we do need to legislate And also one more thing.
There'll be a wider discussion on that, Dr. Usha. I think we leave it.
One more point. Last point is also we have a lot of other statutes. We do have statutes like Sale of Goods, Carriage of Goods, Digital Signatures Act, Construction Education Payment Act. Under the Consumer Protection Act, there's at least 9 regulations.
We will be discussing that with Sichin's session, okay? So let's
I won't touch on it. I was going to say this to introduce Sichin's sessions, but when we talk about codification of law, there's a lot.
Okay, thanks, Dr. Usha.
All right, thank you.
Dr. Usha's provocative statement is a challenge, but I for one disagree. The Code of Contract Act need to be reformed. We are not saying that the code should be comprehensive. We are not saying that we are eradicating reference to specific statutes, and whether bad draftsmanship of Companies Act therefore subvert the very idea of codification of duties of directors. Is bad draftsmanship is not because you don't codify. Otherwise, you have a 19th century Contracts Act principles governing contract law. Yeah.
Prof. Philip, I'm not talking about the word codification. If we put it in writing, we make it an act, no problem.
Of course.
But if you use the word code, that creates a lot of different words, different concepts.
Issue of okay, we will not be distracted by this.
Okay, sorry, I just wanted to say my
but I would like to congratulate Dr. Usha for pointing out to us the stresses on the whole issue of the privity of contract. I want to urge all participants to also click on the chat box, all right, and put your observation, your questions. I myself have placed a few observations, and Dr. Mei Chong has helpfully pointed out to us an Australian decision of Trident. We have wider discussion in the chat box, which I welcome anyone to make observations, and I would like to encourage all participants to click on the chat box to have a look at what's the discussion following Dr. Usha. What Dr. Usha did is to helpfully point out to us the existing law, the stress and tensions, the issue of exceptions, where judicial Malaysian judges actually have tried to find a way out of completely shutting out a third party which has entitlements, but because of the privity doctrine is shut out of enforcement. We have also seen jurisdiction amending the law. Let me just add, as a finance lawyer, one of the driving force for UK and Singapore is that they want to be a financial center, and I think Hong Kong has that too. Dr. Majid, you can confirm otherwise, amended the law because you have complex financial syndications where third parties are granted obligations and also benefits. To shut these parties out in these very complex syndicated loans and credit and security is to doom the center from being a financial center. Hence the impetus, as we all know, advanced capitalism always make quick amendments, whereas poor consumer protection, which we will soon hear from Sichin, will trail behind, and notwithstanding the structural mechanism, we still have the issue of cost of litigation. But today we have a good presentation that kicked off, and once again showing the limits of the Malaysian Contracts Act with the Indian Contracts Act. But one query that I thought we should research on, perhaps May, you can ask our Indian professors, where does this phrase any other person, that means consideration can move from a party other than a province, where did it come from in 1872? All right, given the earlier law of Tweedle and Atkinson and the older law even before the Dunlop suffrage's case, all right, it gives rise to an interesting play of ideas. In the chat box, I refer to Paula and Mulla, my latest edition in my library, where the Supreme Court have also adopted Lord Wilberforce, and our Privy Council decision cited even in McKendrick's book, all right? McKendrick is a well-known contract law jurist, and McKendrick made very telling critique of Dunlop suffrage's case. Worth a read for those of us who are both practicing lawyers and academic-minded. Usha, you put up a hand. You want to say something in closing?
Oh, no. No, I have nothing to say. I think we need to move on. because I
Okay.
don't,
There are questions by Cheryl, but yeah. So the three top reforms, I would say, let's adopt the UK and Singapore Act. They actually mirror one another. Singapore copied from UK. All right, we need that so much. And then we have a gentleman, the name escapes me, he wrote in Jawi. Thank you for the insightful lecture. Interest in e-commerce. I think, Usha, you gesture towards it. There are numerous contracts, for example, clubs, subscription to a subscription agreement, or a member's charter. There's an old law in even our textbooks where parties may not be direct, but it can have rights and liabilities and even enforceability. But these issues are straining at the law where we think that only immediate parties, all right, in a contract. The lecture was indeed insightful. Dr. Usha, terima kasih. Thank you so much, Usha. We shall move on. Appreciate your contribution to our discourse. Majid, before we leave, did Hong Kong pass such a law on privity? Are you aware? Dr. Majid, are you there? Can you unmute? Quick answer to it.
No, I don't know the answer to that.
All right, sorry. Dr. Majid need to update his law. He has left Hong Kong for some time. Hence his gray hair, all right? Welcome back, Dr. Majid, to our shows. May, you want to say something?
I just want to check with Dr. Ushani, from the many cases that she has already raised and all, did the courts at any point of time themselves make any indication whether they feel that going by way of exceptions is too cumbersome, and whether there was any consideration whether they would like to see reforms happening from the legislature?
I think she mentioned Malay Ishaq's case, May. Well, we need to read the whole case. Malay Ishaq seems to observe in Raz Shah. All right, the PowerPoint will be sent to all of us. Have a quick look at that. I think we would have a quick look at that, and we will see whether we move this along. Okay, unless Usha want to add anything more.
No.
If
Thank
not,
you.
Very good. Thank you so much for this lively session. It's a great opening. I now hand over the meeting to my illimitable friend in the Malaysian bar, Anand Raj, who is head of Commercial and Tax Committee in the Malaysian bar. We all know whatever we think about Malaysian bar, we always focus on human rights. Nothing wrong with that. But what about consumer rights, protection, commercial law? And Anand Raj is our champion there. And I'm very happy to allow a very learned and senior practitioner who is with Monsieur Shen, a very respected law firm. And we will ask him now to take over the next discussion and introduce our next speaker. Anand, over to you.
Thank you, Philip, for those kind words. I think you've overrated me significantly. My practice areas are competition law and tax law, and I chair the Corporate and Commercial Law Committee, and there's just there seems to be a renewed interest in these areas because I guess the pandemic, a lot of things have moved away from traditional models and traditional contracts into online platforms and digital contracts and what have you. So I think it's timely that we're going to have a presentation by Dr. Ong Zi Chin, the next session, which is entitled "The Need for Legislative Intervention Relating to Unfair Contract Terms in Electronic Contracts, a Malaysian Perspective." So we all know that when you have electronic contracts, you either click accept or you can't. You just can't move forward. And where does that take us? So just a few quick words to introduce Dr. Ong. She's a senior lecturer in the Faculty of Law, University of Malaya. She started her academic career in 2010 and has published extensively, both nationally and internationally. She received the Best Paper Award for her paper entitled "Mapping Privity of E-Commerce Consumer Contracts for the Sale of Goods in the International Conference on Business, Education, Innovation and Social Sciences" in 2019. She also published a book entitled "Remedy Contract Pengguna Amalan ASEAN dan Barat" with UKM Press in 2018. Her research interests include consumer protection law, law of remedies, alternative dispute resolution, and e-commerce law. So Dr. Ong, perhaps without further ado, I can invite you to start your presentation. And we'll try to take some questions in the Q&A session after this. Thank you so much, Dr. Ong.
Thank you so much for Mr. Anand for the introduction. And I am just a new young academic in this area. I'm doing a research. I'm still learning. This is part of my interest, particularly on consumer protection. And since Prof give me the title that we must relate it to Contract Act, so I quickly choose on to exclusion clause. Actually, I do not claim that I'm an expert in this area. There are so many experts here. I'm just a new learner. I would like to learn and open discussion, and maybe some of the ideas in this area I would like to share with everyone here. So again, I concentrate on electronic contracts. You know, as you just now, Mr. Anand pointed out. Now, because of the COVID, e-commerce, sharing economics, is with us. Particular, I would like to discuss more later on competition. Actually, I did some work on that as well. So I'm still writing a paper. So this is my paper, right? All right, just show you the outline. I will discuss on what is the position of unfair terms in Malaysia, right? I will then concentrate on electronic contract and standard form contract. So why the rationale, why we need to actually have unfair terms or govern unfair terms in a way of legislative intervention. We already have a judicial intervention in the case law, right? Why it is not sufficient? So why do we need that? So then I move on to consumer protection. Yes, we have a new amendment, not quite new, but 10 years ago, which part 3A on unfair terms, right? What is the issue relating to Consumer Protection Act, particular procedural fairness and substantive fairness, and some comparison, right? And also open for discussion and some concluding remarks. This is my outline. So again, Contract Acts that we know which Prof. Susinadrai and everyone have know that we have do not deal with the terms of the contract. So implied terms and express terms are basically the content of the contract. So mainly Contract Act is on the formation, right? So again, quite contract, again, on the violating factors, we have misrep, mistake, undue infant, all those things, right? So that is actually on a procedural unfairness, kind of procedural unfair. Later we'll move on to what, again, procedural unfairness, what is different, right? So procedural unfairness, basically when the time contacting, right? No agreement on the objective intention, the consent is defective because mistake or undue infant, duress, whatever reason, affecting the consent. So therefore, that part of the law need to be regulated, right? So we contract have on that one. But how about terms, right? When you enter into a contract with terms, right? Some part of the terms you agree, some do not agree. How about standard form contract? So then we come about substantive unfairness. Again, the argument that why we do not, the common law or the Contract Act, the old contract, do not require regulating, on this unfairness, because substantive unfairness, right? They rejected that. They say it's not necessary because if we have the law protecting procedural unfairness, then it will guarantee substantive unfairness. Is it true? Right? Not necessarily so. When there is come to a standard form contract, we also have terms inside. Right? Substantive unfairness, of course, is undesirable. So it replaces the party autonomy, right? Because freedom of contract, we know the will of the party had to be, autonomy of the party had to be respected. So if we went to a substantive unfairness, it's kind of induce some paternalism or in intervention, right? In governing what should be deemed fair. So how about party agree that, hey, this is, even though the terms are not fair, so the content are not fair, but we happily, we agree, so I'm willing to take the risk, I'm willing to do that, right? So as on yesterday, we've seen Shermay talk about liquidated agreed damages or contracting out, right? So all these are the issues. So substantive unfair is impracticable. The court say it is basically, the court are not competent to actually know what is too much of uncertainty, excessive uncertainty inside to actually want to know the terms to be fair. Which term considered fair? Because you are doing an act in balancing the economic risk of the parties and the party interest, right? So how do we do that, right? So again, on the burden of proof thing, right? So unfairness, substantive unfair may be part of the burden of proof, right? So they operate as evidence for procedural unfairness. Again, this actually mixed with procedural unfairness and substantive unfairness, because on the consent, whether this consent is free consent or we call it, it's not my term, I borrow from Amindi Chen, right? He said that it's defective consent. So the consent have been tainted, right, because of the terms, right? Let's look at electronic contract because we know that e-commerce, right, everyone sharing economics. So in our government also following the trend. So we have Electronic Commerce Act 2006. Again, I do not want to go into detail what is related to electronic commerce is governed by Section 5, right? So any commercial activity related to e-commerce, what I call exchange in the internet form, right? There's a definition on that. Okay, and again, Electronic Commerce Act as well do not govern the content of the contract, right? So that is also similar to a formation, but it just basically recognize that by way of messaging, communicating, so that is following offer acceptance, is done, right? That is considered as part of the contract. So that is allowed. They have in Electronic Commerce Act, we also have electronic signature and all those things, right? That is to facilitate particular e-commerce, right? So e-commerce, there is a lot now. We consider digital economy. E-commerce is just one part. It's not about selling or buying. We have software, right? We have this development of what you call cloud and all this, right? Games, right? You're buying now banking industry, and all this are include inside digital economy, we can call it. E-commerce is just a small part of the big digital economy, right? So again, because of this, we have recognized electronic contracts. So most of the time we found that electronic contract is, when you click, there is standard form contract, right? Particularly US, right? You have, now we are using Zoom, right? So how about not just in the consumer perspective, but how about in businesses? Now are subscribed to Zoom. Are we individual negotiated the terms? Is it a standard terms which we click only to accept, right? This also involves businesses. So just look at some of the standard form. Just now we are mentioned about defective consent. This consent have been affected. How it is affected? Let's look at the problem is standard form contract. So there's not involved bargain. Basically, there's no negotiation. Standard form is a pre-ready one-sided contract. I don't like to use that word, but it is the profiteering parties, the one have a better bargaining power, or the industry player, or the what you call dominance player, right? Set the terms, set the industry standard, and set the commercial standard. They tell you this is standard form, and they decide what are the terms to include, what are the terms to not include. So basically, not just consumer, I think in certain extent, small businesses and Microsoft and all this, we don't have a choice. You don't have any negotiation in place. So the negotiation or consent, it is not in a meaningful sense. You just click and accept. So basically, in a form that you take it or leave it, these are the standard terms. You want to use the service, that's it, right? So again, the adhering party, so you have the weaker party in the sense, often unaware, right? So again, sometimes they do not able to access to the terms and conditions, right? So then again, rise of e-commerce in this area, right? Not just e-commerce, we include also the digital economy, right? So there's few type of contract, right? But we know that this is a string wrap contract, right? What is this particular software contract? Okay, they buy the terms, the content. If the terms cannot be seen, agreed until the product is bought. Normally, you have to pay first, then only you can see the term. This is what we call the string wrap contract. We have click drag. This one very common. I agree. You must agree to the terms, then you use, right? So there is everyone click. I agree. How many have time to actually read? So later we go on to that, right? We have another kind of contract, bounce wrap, right? So term of use of website download. You have to download the product, right? They have another link to their terms and conditions, right? Whether it is how many people will actually find the terms to read. So I don't say that it is only applied to consumer. Yes, in particularly in consumer, but businesses also, particularly now we are all in Zoom. We all subscribe to their terms and conditions, right? Even their privacy setting, right? We also, the GDPR, recently have made an amendment about the readability, also language of the privacy. Of course, I do not discuss on that. So we are just looking at the unfair terms here, right? In some time, there is also the terms they send after a contract is made over telephone. So they'll call you and agree, do you agree on this financial package, whatever, right? Yes, I agree. Then they will send you the contract later on, right? This is a common standard form contract, right? What is the problem? Again, I would say it not just affect consumer, it affect both. Like let's look at some empirical, this is only some, there's a lot around that. Empirical study on electronic contract, right? So this is 2009, there's an empirical study in US, right? Under this empirical legal study paper, again, they ask a question, who read these 5 prints, right? So you'll be surprised how many actually read. So the survey actually concluded in the most conducive environment in your office or your own home, your own comfort place. So do they actually read this software contract? But they just use software contract. I will conclude that not just software contract, any standard form online contract, electronic contract will have a standard terms, standard form contract, right? So they say that 1,000 retail software user, they only access the license agreement more than 1 second, just 1 second, right? Is your comfort or your zone? I'm sure we don't read. No one have this time to read all this, the small tiny terms. We just want to get to it, to use it. And also the magic 7, right? For consumer, the psychology study has done that. Right, if you give normal people more than 7 information, they can't comprehend, right? Not normal people. Again, that is on consumer. We have argument on reasonable consumer and 2, the vulnerable consumer. So I do not want to concentrate on that because we are on electronic contract, right? So again, a tiny portion of the text is on those who only read. If those who scroll down and read, it's only 47.7 seconds they read, or 29 seconds they read the contract, and how much they can read, right? So there's a lot of studies. There is study in 2020. They say how much time you need to read the terms and conditions of the apps. So they concluded that you need actually 17 hours to sit down and read, right? So I'm not just even they have the study also concluded that even law students, lawyers themselves, right? They read, they can't understand. How many of them actually read? Actually, they done survey on law students as well, right? So that is readability is a problem, right? So again, New York Times, right? Basically, they say they study 4 major seller software standard form contract. This is about 74,000 words itself. Is first book of Harry Potter, right? So there's a lot of study on browse read and click read. So basically, they found that the terms are difficult to read, right? Hard to understand. Readability is a problem. How about your consent? So when you click, you agree. So this consent is not tainted with validating factors. It's not undue influence. It's not. But how about the terms they show you? Right, it's part of the term they want you to see, but most of the term you don't. But when you click, you actually agree on all. Right, there is also I just learned that the recent study by Richard Rice, and also he wrote about dark contract is basically on the transparency of the contractual terms. Right, let's move to Malaysia on equality. So why this standard form contract existed? We know because of the industry player. So the big players set the standard. This is the industry standard. This is our terms. You have to accept that. They will tell you generally they are standard, but are they really standard? Right? So the inequality in the bargaining power have long been recognized in contracts. So we don't have an equal bargaining power. So I will argue that not just consumer particular, but businesses as well. Right? I don't think even though businesses some of the small businesses will not have the same bargaining power as compared to the largest player, right? So again, Malaysia judicial intervention has since in 2001, we have Syed Mawi at both our court of appeal cases and American International Assurance, right? 2002. So again, both are court of appeal cases. Some is actually, one accepted the doctrine of inequality of bargaining power, right? So they mention of unconscionability. One is actually rejected and say it is unsure apply in Malaysia. But later on, we have 2019, particular on CIMB Bank case, just how Dr. Usha also mentioned. But again, this is our limitation on contract. So this is typical exclusion clauses. We don't call it unfair terms yet, right? It is an exclusion clauses exclude legal proceeding. So we don't have any tools the court or to use to actually govern these terms itself or exclusion clauses, right? So we very rely on Section 29. Section 29 is only particular on the legal proceeding or restraint or trade. We have few there to declare the agreement void, right? So again, do we need a legislative intervention? So I would like to report that we need a legislative intervention, because if not, there will be widely use of exclusion clauses. There's no limit. So if you read all the standard form contract, all these, there's no limit. Basically, they don't tell you there's any limit for the exclusion clause itself, right? So why now we came to why rational, why we need to have legislative intervention? Because lack of transparency, particularly on standard form contract, is unclear. So the language they use, right? So legal language, sometimes it's a different American contract, you know, China contract, their legalistic language itself is different, right? Small print, unavailable, complex, density, and there's fine print, very confusing, and the layout was not for the people to read. It's very small print, you have no, right? Again, it is this who said this thing, they said by this commercially profiteering parties. They are the big player who set the commercial standard and the standard form, right? So again, we suffer from information asymmetry. We do not know what are the terms, what they govern and what they do not. Or sometimes they might highlight you certain important terms which they want you to see, right? But it's not all, right? But once you click, it's applied to you, right? This unaware of the inherent risk, we do not know what is the consequences. Is now we all subscribe to Zoom, right? What is the consequences of this? What is the effect of our data protection? Do these things store in cloud somewhere, right? Our record, right? Do they have access of our detail? That is the inherited risk we have. Again, lack of informed consent. Why we need to have some legislative, some control over the use of terms, right? And particular exclusion clause and also unfair terms. So the consent, I would like to say that the consent you given is defective, is affected, because in the first place you do not negotiate. There is no fair bargaining power. You don't negotiate the terms. So doubtful on the consent, whether we give consent to all terms or one particular terms or what other usage. We only generally know that we click for usage, we pay this amount of money. So what are really the terms inside? No one knows. And none of the core terms are targeted. Normally they show you what they want you to see. So they are not give you the core term, right? Automatic invalidity of some terms or invalidity of some others. How about we agree to some, we seen some, we agree on the website, but how about that is detailed terms subject you to, just now we say the browse track, click track, you have to download, so no one is, right? Again, this consent was given is a blanket consent. So when you give consent, it includes everything, right? It's consent to everything inside. There's nothing is actually, but then again, this consent is not affected by validating factors. There's not mistake, there's not undue influence. You have consent. We want to use, we agree, then that's it. Again, there is a problem with the institution of contract, right? It suffers to institution of contract. This standard form contract particularly, right? It binds the party for unconsented terms, right? So how about the terms we do not consented, but once you agree, it bounds you, right? They undermine the reciprocity content in the core terms, right? Again, our contract autonomy have been affected, right? Do we really have a bargaining power do we really have a freedom of contract in this, right? They string the rights of redress. Again, we have seen the CIB Bank case, right? So you can actually, they exclude legal proceeding. They can do that, right? So again, do this kind of clause itself, the unfair terms or exclusion clause, that actually kind of force out the court remedy jurisdiction, because you can say that, oh, in terms of this, you cannot go to the court, right? These are not governed by the court, right? So all this thing, right? Or the arbitration clause or arbitration terms itself is impossible, right? So again, now let's move on to a little bit on Consumer Protection Act. So again, contract acts are following the Indian Contract Act. Similarly, Consumer Protection Act, when they introduced the Part 3A, we also influenced by the Indian Law Commission report on unfair terms, right, on the substantive contract 2006. Again, I would like to say Consumer Protection Act also have its limitation, a lot of limitation. Even though this unfair term was introduced in Consumer Protection Act, again, Section 2.4 of Consumer Protection Act mentioned that it is only a supplementary act in nature, right? Without prejudice to any law regulating contractual relationship. Again, Section 2.4b, application of this unfair term in Part 3A, similarly put a limitation, right, on the application of this. And Consumer Protection Act is only applied to consumer as a contracting party. And for your personal use, right, all this have been defined and also that interpret in the Consumer Protection Act itself. So it is limited, it's not governed by all the other contracts, right? So again, I know Dr. Majid have written a book on sales of good and without prejudice have greatly discussed that, so I do not want to go on to that in detail. So what is without prejudice, right? So that is basically, you would not, Consumer Protection Act is limited. So even though they define standard form contract, they provide for unfair terms, right? Another problem with Consumer Protection Act, let's just look at the unfair terms itself. Consumer Protection Act provide for procedural unfairness and substantive unfairness in Section 24C and 24D itself. So we separated out procedural unfairness and substantive unfairness. So how do we actually balancing all this procedural and substantive unfairness? Obviously, it's required court interpretation. But unfortunately, for consumer protection, it is for consumer claim, it's too costly to go to court, right? Normally, it's tribunals. We only have the went to tribunal, right? So even though tribunal extend their jurisdiction to 50,000, just like a small claim court, right? But then again, very few cases, I mean, so far, after 10 years they have introduced it, we haven't seen the case actually discussed on procedural unfairness and substantive unfairness in court itself, right? So we, how to balance these two, and I would like to say that procedural and substantive unfairness is quite interrelated, right? Substantive control for ensuring fair, balanced contract. How do we have this kind of control on the balance of the contract? Right, balancing act itself, this is something the court or the tribunal need to do. Right, let's look at European Union Unfair Contract Directive. Right, they use the test of unfairness, but this test they provide certain guidelines. The tests are provided under Article 3. Right, they clearly say that there are significant imbalance defined. Significant imbalance, again, this significant imbalance focusing on substance of the terms, right, and good faith itself. Okay, I would not go into that for good faith because later my esteemed colleague, Dr. Noor Hidayah, will actually go into detail on good faith. Right, this not my area, right? So both good faith itself, of course, is related to both substance and question of procedural fairness. So how do we separate these two out? That is a problem in Consumer Protection Act. We haven't seen any judicial interpretation on this. That is the sad side of it, right? Because it's under a subsidiary act, right? So for UK itself, it switched from regulating only exclusion clause. Exclusion clause, we know that is under Unfair Contract Terms Act, ACTA. Right? ACTA itself is only limiting exclusion clauses, but not unfair terms, right? Because for Consumer Protection Act, they have under reform again. So they introduced Consumer Right Act 2015, include the test of unfairness. They moved from a test of reasonableness to test of unfairness, right? Again, on Australia and Canada jurisdiction, they use unconscionability, right, to regulate the standard terms, right? Again, these unconscionabilities require both substantive and procedural analysis. So that is a problem. How do we separate it out altogether? Right? Again, lack of certainty in assessment of fairness. How do we know these terms are fair for one party and the circumstances of the party, the factors affecting the fairness of the term itself, right? This clearly requires court interpretation, right? But unfortunately, it is only on the Consumer Protection Act, right? So again, let's look at. Sorry.
Sorry to interject. I know we started your session is slightly late. But
I ran out of time. Okay.
No, you have just maybe 1 or 2 minutes to wrap up.
Okay, all right.
Anand, it should be all right. I think those who want to stay can stay. We can carry on. Don't worry. Yeah. Okay. It's all right.
Okay, I have
not too long. Not too long. Yeah.
Okay. I will quickly wrap up. Sorry. Yeah. So there's too much. So unfair contract terms, I'm sure everyone know, is only exclude just like I mentioned, the details here, okay, after the reform of this law, Commission's Court Law 2002 and 2005, right, they actually regulate unfair terms, and from the reasonable clause itself, they're limiting this exclusion clause. And now they move on to Consumer Protection Act, and of course, requirement of good faith was here, right? So again, this basically, I would like to say that this EC Unfair Contract Terms Directive is a consumer protection model. Again, they separate out consumer contract and these normal business-to-business contract, right? They undergo 2019, again, a new deal for consumer, a review for this unfair contract terms, right? So again, now we come to ASEAN. So ASEAN also, ASEAN is not a law as per se. We don't have an institution, right? It just they do recognize that there is a standard form contract are not being negotiated, right? So there is imbalance between the rights and obligation of the parties, particularly on consumer, right? So again, they put the test of reasonableness to check on these fair terms. Again, tests of reasonableness have not been used or widely discussed in the unfair terms in Malaysia jurisdiction, right? That is a problem for us. Again, how do we follow this? Even though ASEAN have provided some example of unfair terms. So I would like to say for ACTA, they have under Schedule 2, right? Section 11, Schedule 2, they have an example on factors, criteria to determine the unfairness or the test of reasonableness, right? So clearly we read this. So why we need legislative intervention, particularly our common law. So notice, Tonton Shuleng Bakin, the incorporation of the terms itself. Right? So signature is a particular problem in e-commerce and electronic contract. You click and you agree. This applies to blanket consent. So I will say that this consent is actually affected, right? So again, cost of dealing, right? So there is inadequacy of our judicial intervention. We know very few until 2019, we see very few terms about exclusion clauses come to court itself, right? So we have to wait for the case to come to court. Then we know how the court think about unequal bargaining powers and also unfair terms, right? So even though the case come to the court, so how do we ensure this unfair term is not in use? It's still widely in use. We don't have limitation on exclusion clauses, right? We only have one cases on the particular section 29 itself, not applied to all exclusion clauses, right? So test of fairness was not used in this judicial interpretation. So again, we are using the no particular problem model. Basically, our law contract act actually tell you there is no problem with consent, no problem with defective consent. Right? So general rules in making contract is just freedom of contract is just you bargain, you agree on the terms, that's it. Right? But we know that the mechanism itself, there is limits on our freedom of contracts, right? Again, RTR had long time say about it. Gremo had write about that for contract. So common law and equity did not regulate unfair terms. They don't have a systematic way, just like Dr. Usha also showed us on the third party. There is no systematic way to regulating third party rights. It's only with the exception. right? So there is no way, I think the court are lack of tools in guiding tools to determine the unfair terms, right? So again, that's why I justify for legislative intervention, which is to provide certainty, right? This is some discussion. So how do we want to do it if we want to what you call regulate unfair terms? So is it a legislative intervention? For example, there is a model like we have particular industry, Housing Development Act. So we actually regulate the industry, the standard form of particular industry. I know this Housing and Development Act, they review the standard form themselves, right? They have a committee to do that. So are we going to do that? So is it possible to regulate all the industry? So again, government, you need to spend a lot on that, right? We need to have a good law reform body in particular industry. So each industry has different standard forms. So are we going to do that for all the industry? So that's one question. So industry and also unfair terms, how do we balance industry standards and the contracting parties, right? So again, this market failure problem, right? Our contract law mechanism is limited, right? So that is that's why I think it can have some discussion here, right? So I would like to propose, if I think there is a general fairness model, which we need to have something of a scope of fairness rule, govern both relationship, not just consumer itself. Consumer, we have Consumer Protection Act. So B2B, business to business relationship as well. They can cover both standard terms, either individual negotiated. I don't say if individual negotiated terms can be unfair, also can be unfair, right? So it should govern both, right? So recognize a contract mechanism. We know that contract mechanism can lead to unfair result. So freedom of contract, that is a problem. There is basically no freedom of contract. No, I don't say no. In certain practices, in certain commercial practices, you know, standard form we do not have. Again, I would like to compare with this Norwich Contract Act itself. Okay, the court actually can set aside or adjust the term of its application lead to unfair result. This Norwich contract terms is actually provide for general consumer and also B2B. So I would like to suggest that. So if we want to legislate unfair terms, right, maybe we can actually study on that. I just want to show you a little bit on development on technology with unfair terms. Right, let me share. So just 5 minutes. Sorry, I know I run out of time. This is the research by, I want to share some new research I found out. So it's called CloudGet, right? They use a new, a bunch of researchers, right, from the European Institute. They actually use a new technology to actually detect unfair terms. Just hold on. How do I share? Hold on. I'm a bit. I want to share you this one, right? Okay. All right. Okay. So this is the new thing they have done, right? So currently still ongoing. So CloudGet that is using machine learning to detect unfair terms and also privacy policy. So this is by European Union Institute, right? So I just want to share this video, right? So it's just.
Have you ever wondered how long it takes to read a service provider's terms and conditions or a privacy policy? And how many of these apply to you every day? On average, for the most popular service providers, a comprehension-centered reading through the terms and privacy policy requires close to an hour for each. And here's another question. How often do you have the time to look for changes?
Right. Okay, that's all. You can read
Claudette
more
is an
about
experimental project born at the European University Institute in Florence. The original aim was simple: to see if artificial intelligence could be trained to help consumers check terms of service for unfair terms.
The link into the chat box and everyone could access it.
yeah, sure. Let
The
me
methodology is as follows.
Okay.
So, Dr. Ong, did you have anything else to share? Zichin, you're muted.
Sorry, I'm taking so much of time. Yeah, that's all I like to share. Right,
But
so
if you put
I
the link
will-
in the chat
yeah,
box,
yeah.
everyone can
I'll
access it.
push the link on the chat box so I can see how they're using technologies. Another school or thought and say that we can using technology to fight technology on the unfair thing. So is currently undergoing this. So thank you very much for listening to me and share my little bit with you. Right. So yeah. So I will
Thank you.
pass the
That
session
was excellent. I don't know, Philip, whether we have time for questions on Dr. Ong's presentation before we move on.
Okay, ask me, Phong. Ask me. It's okay, Anand.
Your hand is going up.
Sorry, I know that we are very time short, but I cannot miss this opportunity to enlighten a little about the law in Australia. I know we're all here to learn, and thanks Zichin for a wonderful presentation. But I thought it was important to clarify that that statement that you made, that Australia uses unconscionability to control standard form terms, which is not exactly the case. I just want to explain the context of it. So we have, in Australia, the Australian Consumer Law, and under the Competition and Consumer Act, it is very comprehensive consumer legislation, which has actually been extended to business contracts and all. So in 2010, there was this unfair contract terms regime, section 23 to 28, which actually follows a bit of the EU EC model, significant imbalance and all. So that part governs unfair contract terms. And in fact, it's going to be amended. And I understand that from next year, it's not going to cover only terms, but unfair conduct, unfair practices as well. So there is a law on unfair contract terms. And unconscionability, which is so rich and so powerful, is a separate regime altogether, which of course we know it comes from equity, from Amadio's case. And now we have statutory unconscionability section 20, 21, 22. And so they are quite two different regimes which are so well used. And then, of course, unfair contract terms would cover exclusion clauses because it is also an unfair term. But I just want to quickly introduce misleading conduct, which of course is much more powerful, which has rendered many of the common law actions of misrepresentation, deceit and all, really swept over because of this statutory provision. And when Ushrani mentioned about statutory exceptions, well, misleading conduct is one way in which parties now go for statutory action rather than the issue of privity and all. So just very quickly, and thanks for giving me the time.
No problem. So I think I would close this session by saying that the law is so dynamic here, and I would urge everyone to look into developments in Europe, especially with the introduction by the European Commission of the Digital Markets Act and the Digital Services Act. I think it's going to cut across everything that we've talked about, competition law, consumer law. It is massive because they've had so many cases and investigations against what they've termed the acronym GAFA, which is Google, Amazon, Facebook, and Apple. So these are the large players and the gatekeepers as they are now defined. So there's a quantitative test on who is a gatekeeper. You've got to be billions of euros in size, and you've got to have, like, say, 45 million or 50 million active users or 10,000 active businesses using you at any one time. You then become a gatekeeper, and then you have certain prohibitions, really in the interest of fairness to consumers and enhancing the competitive landscape. So we won't have time for that, of course, but I would urge everyone to look into the Digital Markets Act and the Digital Services Act that have been introduced in Europe. So I think with that, I can hand you back to Philip for the rest of the session. It's been a wonderful experience for me to catch up on some of the old contract law principles, and there's so much to be done. And I was reading through Justice Mary Lim's note, which I think she read out on Saturday, and I think this area is ripe for reform. And I think the bar certainly is going to be keen to be working with and others on this. And thank you very much, Philip, for having me on board. And I hand it back to you. Thank you so much.
Thank you, Anand. Thank you. Thank you, Sijin, and thank you, Anand, for ably moderating. Sorry to cut off the discourse, but there are so much that excites us now. We realize that, as I use that metaphor, the lens on a single area relates to so many intersecting areas of contract law despite the fact that legislation has stepped in to deal with the complexity of the digital electronic environment in particular, and even standard form contracts in general. So we are very, very grateful for Sichin for exposing us in a very provocative way that much of our contract law principles, reading from our old textbooks, for me 30 years ago, I need to update now, to the new modern way of looking at contract law, which requires convergence of so many areas, right? Because of the web and the internet and electronic, the regulatory mechanisms of law is training in its doctrine and its functionality to deal with the whole issue of even consumer protection. With those brief remarks, I would like to move the conversation forward, and I invite now Dr. Ong, who is no longer a presenter, but now would be a moderator, to moderate Dr. Nura Hidayah, and also to introduce our next speaker. We will cut across to 6 o'clock, and perhaps we will wind down by 6:15 or so, okay? For those who can stay on, please stay on, and leave a note to us to encourage us. And we now hand over to Sichin. Over to you to introduce the next presenter.
Thank you, Prof. Lee. I would like to introduce our esteemed colleagues, okay, Dr. Nur Hidayah Abdullah. She is currently our senior lecturer at the Faculty of Law. Okay, her research interests lie broadly in contract law, business law, and related aspects. She specializes in good faith in contractual performance. That's why I will leave the good faith to her. That's not my area, right? Her recent publication include the book entitled "Good Faith in Contractual Performance in Australia." Right? She was also invited by the Chief Justice of Malaya to actually present a presentation on good faith in contractual performance, a case of marriage by the judge in the Palace of Justice in Putrajaya. And before I hand over to Dr. Nur Hidayah, so I would like to share, right, Dr. Hidayah new books on good faith in contractual performance in Australia, right? So anyone who like to have a copy of this book, right? So the form is shared here, right? You can actually go to the Springer and have a look on this book, right? Right. Thank you, and I would like to invite Dr. Hidayah to continue the dialogue. Thank you.
Okay, I'll share my screen. Right. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good evening. Thank you, Dr. Ong, my colleague and moderator for the session. I would like to express my gratitude to Professor Philip who gave me this opportunity and encouragement. So today, I was honored to be given this opportunity to share my topic entitled "Towards Codifying the Principle of Good Faith for Malaysian Contract Law." Right, this is the my tables of content, which I will discuss. Introductions of the concepts of good faith, the civil law and common law approaches to good faith issue, its meaning, and I would like also to draw attention in other jurisdictions such as USA, Australia, and People of China, and I'll also discuss a bit on good faith in Malaysia, and I will conclude with conclusion and recommendation. As an introduction, right. The law of contract had undergone so much transformation in lieu of political, economics, and social, particularly due to laissez-faire. Yeah, so laissez-faire, or known as free market, there is a less intervention from the government. Yeah, during the periods there is a transformation from classical theory of contract to modern theory of contract. Right, the classical theory of contract is based on theory of will, the intentions of the parties. Okay? So it propounds the idea that freedom of contracts and sanctity of contract where it depending on the bargaining power. This means court is not allowed to interfere when the party had deal with arm's length. Okay? But the classical theory of contract is said to be biased. Yeah, so the issue of the bias is because of inequality of bargaining power, widespread use of standard form of contract. I think Dr. Ong has discussed a very comprehensive the issue of widespread of standard form of contract, where, for example, online contract, yeah, where you don't have, the party don't have the power to deal. I mean, it just based on take it or leave it. Okay, so if you want, you have to abide the rules. Yeah, and finally, the emergence of many economic activities that had caused injustice and unfairness. Yeah, right. So they moved to the modern theory of contract, where it usually based on theory of exchange, where exchange of goods and services is expected to be fair and justice. Yeah, so contract is expected to uphold value for fairness and justice. All right. Well, from this, it gave birth to many equitable doctrines such as unconscionability, non-aggression from grant, fiduciary obligation. Yeah. Nevertheless, yeah, good faith, yeah, emerged as a modern armor of contract law. Well, I would like to quote this from Professor Chong Mei Fong. Professor, yes, I read your articles about it. So I would agree that good faith can be a modern armor of contract law. Yeah, right. Now, so Locke Bingham, yeah, has described good faith as the most important contractual issue of our time. Yeah, so look at the landmark case in the case of Interphoto Picture Library against Stiletto Visual Program. Yeah, so Locke Bingham implied the concept of good faith and held that. So in many civil law systems, perhaps most legal systems in the common law world, the law of obligations recognizes and enforces an overriding principle that in making and carry out contracts, parties should act in good faith. Okay, so what is good faith? Yeah, well, we'll be talking, we heard the term good faith from Dr. Usha and then Dr. Ong. Yeah, so, well, I'll discuss about its function. Yeah, so good faith by John Carver and Peter Kenchite. Yeah, so they explain that good faith is a term which is expected that the contracting parties, both parties, have to take into account other party interests when exercising their contractual rights, right? So Burroughs, yeah, in 1968 explained its function. Yeah, so the concept of good faith is regularly invoked not only to condemn deceptions and lack of candor at the time a bargain is concluded, but also to require forthcoming attitude to condemn chicanery, sharp practice in the carrying out of contractual obligation. Yeah, so it means that it has a wider and holistic function. Okay, but is this good faith is something new? Or, well, it's not. Yeah, the answer is not. The duty of utmost good faith of ubi mari fide in insurance law was introduced almost 250 years ago. Okay, in the landmark case, Carter against Boyum, 1766, yeah, where Lord Mansfield commented, the governing principle of good faith is applicable to all contracts and dealing. So good faith forbids either party from concealing what he privately knows to draw the other into a bargain from his ignorance of the fact and his believing to the contrary. Right. So I move on. Right. So what is the role of good faith here? Okay. So the good faith, well, you look at the first point, it acts as a gap-filling term, which supplements the express term of a contract to prevent uncooperative or unfair conduct, right? So, and the second point, the function of the duty is not to override the express term of the contract, but to facilitate the vacuum of the contract. So I repeat again, is to facilitate the vacuum of the contract. And good faith is usually used as a tool of interpretation due to its flexibility in nature. Good faith has many meanings, so we can choose the proper meaning that suit to the expected benefit of the contract. So I will discuss more about good faith in the next slides. Right. Now, I would like to discuss a bit of historical background. Where do these terms come from? So of course, in a civil law country, so the features of Roman law characteristics of the civil law system is bona fide. And what does bona fide means? So bona fide means one's word must be kept. One's conduct should be in exact conformity with promise. Mean it concerns more about promise. So the underlying themes of bona fide is to ensure justice and fairness to be upheld. Right, and you can see many of the civil law countries in Germany, Italy, France, so they codified the words good faith. I just would like to draw one right here. You can see in Germany, Article 242. So it's stated here, the debtor is bound to perform the contract in accordance with good faith, having regard to common usage. Right. So how it was interpreted, so look at the Article 157 here. Contract shall be interpreted according to the requirement of good faith, ordinary usage being taken into consideration. It's a bit loose, but it's a bit loose definition. Again, you can see Italy, France. My next slides, I have Switzerland, Greece, and Netherlands. All make reference to good faith. Right. Okay, this is thing that I think is very interesting when I was doing my research. That's interesting to note that there is a tendency of common law lawyers to refer to civil law. This according to Nicholas. So it's in the law of contract also that common lawyers have most often looked to Roman or civil law. Well, I think I would like to pose this question to the lawyers here. Do you agree with these statements? Right, so perhaps you can answer me at the end of the sessions. Right, okay, in the next slide, how about good faith in common law country? You must be wondering, good faith in common law country. Well, in English law, good faith is considered as a foreign rule, where the notion was not recognized. I mean, they don't like good faith, Well, English law tend to use specific legal notions rather than a general principle to control unfairness. Right, English law is more concerned with the parties' expectation by way of interpreting the intention. So this expectation is in line with the outcome of the contract. Now we look at case on Walford against Mark. The concept of a duty to carry on negotiations in good faith is inherently repugnant to the adversarial positions of the parties when involved in negotiation. So each party to the negotiation is entitled to pursue his or her own interests, so long as he avoid making misrepresentations. Right. So, and the duty to negotiate in good faith is as unworkable in practice as it is inherently inconsistent with the positions of the negotiating party. So I think Locke and agree with the classical theory of contract. Right. Does it mean that common law do not generally conform to requirements of good faith? Well, in common law, there are other legal concepts that can overcome issue of unfairness, contractual injustice, of unequal powers, such as unconscionability, fiduciary obligation, non-derogations from grant, and the common law duty to cooperate. Yeah, right. Now we look at the international level. Yeah, so good faith is not just civil law concept, yeah, but it being accepted, yeah, in international level, yeah. So many international trade instruments incorporate good faith. Now, I would like to draw attention in this case, yeah, in a nuclear test case, Australia against France, yeah, the International Court of Justice claimed that one of the basic principles governing the creations and performance of a legal obligation, whatever their source, is the principle of good faith. And there are other international trade instruments that mention about good faith. For example, these United Nations Conventions on Contracts for International Sale of Goods, Article 7.1, yeah, known as Vienna Sale Convention, yeah, which provide that in the interpretations of the convention, regard is to be had to its international character and the need to promote uniformity in its application and the observations of good faith in international trade. You can see here the words good faith, yeah, is regarded as international character. Again, you can see in Principle of International Commercial Contract, UNIDROC. Yeah, again, it was mentioned in Article 1.7, where it stated that each party must act in accordance with good faith and fair dealing in international trade. Okay, you can see also Vienna Convention, Article 26, Article 31, Clause 1, Principles of European Contract Law also mentions about good faith. Right. Now, the next slides, I will discuss about good faith issue, its meaning. This is a very problematic, I could say, problematic issue that been addressed by many academic and scholars. Yeah, right. Good faith and many of the meanings are contradictory and confusing to each other. Yeah. But my research proves that good faith can be defined. Yeah? So the most common definition is honesty. Yeah, honesty. Yeah. So as you know, honesty is the best policy, right? So it receives support in the case of TAS contractors against Placer. Yeah. So Templeman J agreed that I think that the obligations of good faith requires the party to deal honestly with each other. Next, reasonableness, wajar. Yeah. So in this case, Biotechnology Australia, again PACE, court held that to fill the lacuna and opine that the law has filled innumerable lacuna in the contractual agreements of party by applying a doctrine of reasonableness. Okay. Okay, so in Armstrong against State of Victoria, Taylor J commented that it is for the court to determine whether particular conduct is reasonable or not, as a guide to determine it. Apart from this, these are also from my finding. Yeah? We have honesty, cooperation, reasonableness, fairness, party reasonable expectation, as an excluder, consider other parties' interests. Yeah, these are the things that from my literature, from my empirical evidence, proof that this meaning associated to good faith. All right, how about multi-category? So in multi-category, define that good faith has more than one meaning. It has two or more single categories as an attachment to its meaning. Yeah? So Mason J formulated that good faith can be expressed by way of multi-category, which include three important ideas. Firstly, honesty. Secondly, the interests of the parties. And finally, cooperation. Yeah. So these definitions receive recognition in the case of Central Exchange against Anaconda Nickel, where Parker J said, you can see here, I don't think I need to read the whole sentence, but I highlighted the three important elements, where to define good faith, it requires cooperation, honesty, and reasonably having regard to respective interests of the party. Right? Now, I think the most important part that I think I would like to share in my finding here, experience under selected jurisdictions. Okay, right. You can, I chose these three countries, because USA, Australia, and People's Republic of China, they're taking advantage of the process of codification. So one of the advantage of codification is its process, it improves the content of law. So the first point I would like to highlight is the code of law is precise in form, which I would like to draw attention on USA, which I will discuss in my next slide. Number two, it provides certainty of law in the legal system, which I refer to Australia. And number three, stated law in the code confirm the changing needs in economics and business purpose, which I found that's happening in People's Republic of China. There are two approaches to codification. Firstly, they translate case law into statute, which without radical change. And the second one, they produce a new set of principles, which USA has proved that. Right. Now, my first country, this is USA, right? So USA is the only common law country that codified the concept of good faith, except Louisiana, because Louisiana is they use civil law approach. So at the early stage, the US court was slow to recognize the duty of good faith in common law contract cases. But later, the concept was codified in uniform commercial codes, and later adopted as a part of restatement second of contract. So the intention of the Law Commission is actually to improve the law by codifying the concept. Since the middle of the 20th century, good faith had attracted the attentions of American legal scholars to employ the concept, particularly in commercial cases. Now you can see there are in the UCC itself, there are at least 50 different provisions. So good faith is defined here, in section 1, which provides that every contract or duty within this act imposes an obligations of good faith in its performance or enforcement. In fact, there is an exclusive definitions of good faith concerning merchant. Right. It's provided here by this Article 2, and it defines what does it mean here. So good faith in the case of a merchant means honesty in fact, and the observance of reasonable commercial standards for fair dealing in the trade. Okay. All right, but there's a disagreement with the definitions of good faith in the code and restatement. So Professor Franz Wolff commented definition was too restrictive because it was basically on honesty. Whereas Article 2, in the case of merchant, the requirements of good faith include honesty and reasonableness. So the reason is rational for a court to imply contract's term good faith is necessary to secure the expected benefit of the contract to a party or to protect reasonable expectation. So Professor Summer, agreed with critique by Van Woest. So Summer said good faith should be conceptual as excluded. What does excluded mean? You don't define good faith. So whatever bad faith is good faith. Right. Now we move on to the restatement seconds of contracts. Where it's a legal treatise. It's not binding. From the second series of the restatements of the law, which intends to inform judges and lawyers about the general principle of contract common law. So it's cover area of contracts and commercial transactions. So this restatement second of contract it first emerged in 1980, and like UCC, is constitute another fundamental and important source of the duty of good faith in contractual relations. So section 205 stated that every contract impose upon each party a duty of good faith and fair dealing in its performance and enforcement. Right? Okay. Unlike UCC, restatement contract mentions about good faith and fair dealing. of course, but again, there was a bit controversy. So they adopt the excluded approach, yeah, by Professor Summer, yeah, which they don't define what is good faith, but whatever is bad faith is good faith, yeah. So restatement second of contract does not have the force of legislations as compared to the UCC, but the state court system of US has explicitly adopted a general obligation of good faith in contractual relationship. Right, in my next set, we move to Australia. Okay, so in Australia, yeah, the first case discussed about good faith was the case of Renard Constructions, yeah, again, Minister for Work. It was only an obiter comment by Priestley J. Yeah? Despite becoming an obiter comment, but it's the concept had been widely discussed, yeah, and many cases has followed Priestley J. obiter comments, yeah. So I just would like to draw your attention about what Priestley J. Stated, yeah, in his decision, yeah. So he implied the concepts of good faith, yeah. So he stated here that the kind of reasonableness I'll be discussing seems to me to have much in common with the notion of good faith, which are regarded in many civil law systems of Europe and in all states in the United States as necessarily implied in many kinds of contract. Yeah, so that's okay. From that, yeah, the more discussions of good faith is spreading, yeah. But until today, I think there's still no High Court decision to discuss position, even though they got the chance. In the Royal Botanic Gardens against Domain Trust against South Sydney City Council, the court refused and regarded that it is unnecessary at that time. Okay. Okay, the reason is because, okay, this is the dissenting judgment by Kirby J. Yeah? So he rejected the introduction of implied term in the commercial contract because it go against the express intentions of the contracting party. And his lordship also commented that appears to be inconsistent with the law, and it has developed in respect of introduction of implied term into written contract, which the party have omitted to include, yeah. And I think the other things that I think I would like to highlight is that the implied term of good faith appear to be contrary, yeah, to the fundamental notion of caveat emptor, yeah, and that are inherent statutes and equitable intervention of parts in common law conception of economic freedom. And I think also I would like to highlight what Cullinan J. commented, that a duty of good faith might deny a party an opportunistic or commercial exercise of an otherwise lawful commercial right. All right, so, but even though the argument is still lukewarm, yeah, and actually in March 2012, the Australian Attorney General Department, yeah, released a discussion paper. So one of the issues that they would like to suggest to reform is the issue of good faith, yeah. But however, very disappointingly, that the feedback received was disappointing because due to its uncertainties. All right. Okay. One that I would like just to draw attention is good faith in franchising code of conduct. Yeah. So you can see here during that time, yeah, the call for good faith in franchisings are due to the allegation of unethical behavior by franchisor and franchisee. Yeah, but in this case, Wynne, yeah, contended that an obligations of good faith should not be defined, but instead, good faith should be incorporated in a manner similar to the provisions of unconscionable conduct set out in section 22 of the Australian Consumer Law. Yeah, it's a list of factors. One of the list is good faith factor. Yeah. So the approach is by way of non-disciplinary reference criteria to assist with meaning, yeah, because the benefit of it will eliminate uncertainty and it will give legislative guideline to facilitate the judges, right? So again, French Institute Code have been amended, commencing on 1st July to 2021. So the code include good faith as the expected behavior between franchisor and franchisee. So the code stated that court may consider whether the contracting party has acted in good faith by considering the behavior of the party. So they have two things they have to consider: whether the party have acted honestly and not arbitrary, and the duty of corporations. So of course they will look at the matters from pre-contractual negotiations, performance of the contract, dispute resolution, and to the end, including terminations of an agreement. Right. The last country that I would like to draw attention is People's Republic of China, which for me is very interesting. When I did the research on this People's Republic of China. So as you know, People's Republic of China is influenced by civil law and socialist law. All right. So the informants of concepts of good faith is parallel with PRC traditional moral and commercial ethics. No confusions. So they propose the idea of good faith. So the reform of contract law is due to the changing needs for economic and business purpose. So during that time, they open the door to the world. So they have the PRC legislated a new contract law of the People's Republic of China, which cover a wider scope compared to the previous contract law. One of the major fundamental guiding principles is the principle of good faith. So I just would like to draw one article. There are many articles which mention about good faith. So the one article which gives secondary recognition is Article 6. The party should abide by the doctrine of good faith when exercising their rights of fulfilling their obligation. Right? So actually, the recognition given to the principle of good faith has brought the law in China in line with the international business practices. So you can see Article 1.7 of the unit right is similar to Article 6 of Contract Law of PRC, which emphasize the obligations of good faith to encourage more business opportunity at the international level. Right, I think the last thing that I would like to discuss is good faith Malaysia. Right, again, there is not much discussion about good faith in Malaysia. So the position of good faith is in Malaysia is similar with English law. There is no general duty of good faith between contractual parties unless expressly stated. I found this case in the case of a Court of Appeal case, Asian Bankers Malaysia again Shen Court, in 2004. There was an opportunity to discuss, but the Court of Appeal held that on the state of the current law, there is no general duty of good faith and fair dealing at common law. But can we adopt the principle? Yes, So my answer is by Section 3, Section 5 of Civil Law Act and Article 160 of FC, which allow the importation of foreign doctrine. We give a wider scope of good faith applications in commercial matters. So since Malaysia is a trading nation, therefore it's high time to apply good faith in contractual performance where the concept is recognized widely. Right, I think I would like to end with conclusions. Right, so good faith rooted in civil law country, but it gaining recognition in common law country. In civil law country, it is included in the civil law codes and international instrument. In English law, there is no general duty of good faith between contractual parties, but English law recognize good faith in many of its legislation. They prefer a piecemeal approach. So the issue of good faith lies in the meaning. It has so many meaning, it's confusing, it causes misunderstanding, but my research proved that good faith can be defined. If you look at my previous discussion, none of the literature discuss the meaning of good faith, or if we discuss a very loose interpretation. So I believe here, as one of the legal concept, good faith can be one of the principles to reform the contract law. Theoretical advantages of codifying good faith, you can see from the discussions that I've discussed just now. So firstly, the code of law is precise in form. You can see it from USA in Uniform Commercial Codes and Restatement of Second of Contract. Study of law in the legal system, Australia, even though they did not legislate the concept, but they have in the franchising code of conduct, yeah, and then in the statute law, it's code confirm the genuine needs for the business activity, particularly in PRC, yeah. So they codify a new contract law. Practical advantages of codifying good faith, you can see that lawyers can plead their pleadings and judge can make decision, right? In Malaysia, Section 3(5) Civil Law Act and Article 160 of FC allows the impositions of foreign legal doctrines such as good faith. So in short, I suggested that Malaysia to adopt the principle of good faith in contract law as part of its reform. With that, I end up my presentation. Thank you.
Thank you so much, Dr. Noor Hidayah, for this wonderful insight of this good faith, right? So do we have some question? Do you want to take some question?
Yeah, Dr. Ong, can I take the question that
Yes,
by
yes.
Jeff? Yeah.
Yes, yes.
It was,
Jeff asked whether a duty of good faith have been implied in UK common law in relation to a contract defined to be long-term in nature. Is the line of cases applicable in Malaysia?
Oh yeah, Jeff Long, yeah. So you asked the question, the concept of relation contracts and implied duty of good faith have been well recognized in UK in recent years, yes. What are the positions in Malaysia under our Contracts Act? Is there a need for legislative reform? Yeah, yeah, good faith come with implied terms, yeah. And recently, I would draw your attention from the Supreme Court of Canada, yeah, the case of can't remember the case, but the Supreme Court of Canada recognized good faith as the governing principles, yeah. So that's a move toward recognition, yeah. Okay, particularly in relation contract because relation contracts, it require a long time engagement, yeah, and when it's require a long time engagement, sometimes they need a better protection, yeah. All right, what is the positions in Malaysia under our Contract Act? So we don't have actually anything on good faith, yeah, in our Contract Act, yeah. Is there a need for legislative reform? Yes, I would agree that we need that because USA have done it, people of China also have done it, right? So and when my discussion with the panel of judges, right, there's a question that asking whether how would we raise such a doctrine where it wasn't legislate, it's only equitable principle, right? So the judges told me that it's good if the parties can plead. I mean, the lawyers plead because of our adversarial system where when the parties pleads and the judges can make decisions. So if you don't plead, I mean, the doctrine, I mean, it's just there. Yeah, that will be my answer to Jeff Leong. Yeah. Okay.
Dr. Noor Hidayah.
Yes.
May I ask a question? It's outside your remit, but let me see whether you can address this.
Oh, yes.
Islamic finance contracts, do they bring in good faith or not? Or do they just talk of justice? Justice in Islamic contract, finance contract, the same as good faith here?
Well, okay. Well, I actually also did some research during my master's degree on good faith in Islamic banking. Yeah, I compared Islamic hire purchase and conventional hire purchase. Yeah, and I discussed directly on the elements of good faith. Yeah, well, there is an element of good faith, husnul niyat, yeah, in Islamic, in the term of Islamic law, which these terms have been used in many of the platforms, musyarakah, mudarabah, yeah, okay. Yes, it is there, yeah, but I'm not sure how far it has been used, yeah. So perhaps the lawyer should please on good faith, husnul niyat, and because there are hadiths, there are surah that mentions about good faith. Dr. Majid, if maybe perhaps you can drop me your email so I can give you the write-up that I've done, so we can have further discussion on that. Is it okay, Doctor?
I would like that. Sure.
Yeah.
I was just thinking about the various chief justices who have talked about bringing Islamic values into the system.
Yeah,
So
because
this is one of the elements that could be brought in.
yes, I do agree with Dr. Majid. When I did my thesis, yes, the element is there. The Islamic jurisprudence addressed the issue. Is in the hadith, in the surah, yeah, in the Quran, yeah. But how far that we brought the issue? In fact, if you can see in the because this concept, yeah, it need to be defined. So perhaps if we define it, it become more certain and it will eliminate uncertainty. Yeah. Yep. Thank you, Dr. Majid. I love to work with you. Yeah.
Thank you.
We have two more questions here. Would like to take. Jeff Leong asked, so COVID-19 has disrupted many contracts, not attributed to the fault of the party. Construction industry have been hit badly, especially the contractor are now insolvent. Can a duty of good faith be applied to the construction contract so that the losses arising from COVID-19 be shared? So what can we do to save construction industry and prevent the failure of subcontractor, supply developer, extra will definitely affect the end.
That was Jeff Leong. Thank you so much for the question. Well, that was the case, the landmark case of the Australian case. Yeah, Priestley J commented that case is about construction. Yeah, the failure of the third party to provide information, but the principal did not know about the failure of the third party and they terminated the contract. So the issue is whether the terminations is being doing fairly or not. So that's why Priestley J in his obiter commented that it wasn't done unfairly. Yeah, because they just decide based on the four corners of the contract without knowing that the reason of the failure of the contract because of the third party. Yeah, so I think Jeff Long, perhaps you can buy my book. So in this book, yeah, I've discussed very thoroughly about Australia. So this is very helpful for you because I discussed about the cases as well, and there were many discussions that I included, especially in construction industry. So the question is, can a duty of good faith be applied to construction contract? Yes. From my research, I think yes, yeah, perhaps implied term, but of course the lawyers have to plead. If the lawyers did not plead, how do we apply? Because my discussion, as told you, my discussion with the judges, they were interested about the concept of good faith, yeah. But I think as long as the party did not plead, I mean, it just can't go far. Yeah, that's my humble opinion. Yeah.
Hidayah. Hi, Tommy, and yeah, we have interacted. Well, I just want to ask that I would just suggest that this concept of good faith apply to the whole range of contract. I can understand the pandemic situation. In fact, the UK government gave a guidance on responsible behavior, which seems to suggest the importance of considering good faith in the pandemic. But generally, I would thought that certainty and commercial reality would be the abiding principle of contract law. So can you respond, please? Thank you.
Yeah, thank you, Chow Mei. It's a very good questions. Yeah, there's an issue actually, whether should we apply to relational contracts such as joint venture, distributorship, because it's require a long commitment. Yeah, because there's also argument saying that if you apply to all contracts, it will jeopardize the four corners of the contract itself. Yeah, so I would agree that perhaps in a common law country, because the concept, because we have other concept that police unfairness, right? So perhaps we can start with relational contract first. But I wasn't surprised when Supreme Court of Canada decided that good faith shall be the guiding principle of contract law. Perhaps that was the latest later decisions that been discussed. Yeah, the case is I don't let me get the case because I don't remember. The case is, maybe perhaps you can check the case, Supreme Court of Canada case that was, they decided the case quite recently, and many of it inspire the other country also would like to follow the Supreme Court of Canada.
Thank you. That's undermine certainty, right? To a great extent. Yeah.
Yeah. Because the problem is good faith has no definition. It has many definitions. It's very frustrating.
Thank you, Dr. Yap.
Okay, we should wind up. Xi
Okay, thank you, everyone. I think we should wrap up the session. I think it's a fruitful event. We have learned something, right? Right, we have learned something, and we have learned from each other, right, to concern on various different areas of contract law itself. So yes, we should move forward, right, on the current trend, right? So on our old English Contract Act, so it is allowed a new concept of good faith, right? New ideas on fair terms, or even the third parties to come in, right? So maybe we would need some new changes in this area. So Prof. Phyllis, this is over to you, and hopefully this webinar is just the beginning of what we are proposing, and hopefully we can see more event and engagement later on. Right, over to you, Prof.
Thank you, Dr. Ong Si Chin and Dr. Hidayah. You mentioned the word dialogue. I also want to mention the word conversations. The great teacher of China, Confucius, says, the journey of 1,000 li begins with the first steps. So the first steps of reform to Malaysian contracts law started long ago by law teachers who has taught many years in our local law schools. I've always said that Malaysian lawyers began their law studies with comparative law studies. All right, we immediately are thrown. We cannot have a textbook like McKendrick or in my day Smith and Thomas. All right, a case book, and then read it out as if that's the law. We have to compare both Malaysian, Singapore at one time too, although they have taken a different form now, and India, and a common law. So our undergraduates are always wrestling with comparative law. Unlike, and this is not a criticism of LLB External London, they only engage on the English law. But then again, even there, they are exposed to the EU law, that is, of course, before Britain became Brexit. Ladies and gentlemen, for those of you who have continued with us, I see 54 valiant participants who have continued to listen to this webinar, and many others perhaps through the Facebook and the live stream that will be recorded there for us to audit again and to reflect. As we concluded the session with Dr. Hidayah, I want to thank her for her effort. I know it's not easy to address in a webinar, and many of us are not accomplished speakers. We struggle along and we make up our way. And Si Chin too, for her able moderation that interface in. We thank you both. That concludes this webinar sessions. We know that the contract law is such a complex web. We have left out major issues on breach, on issues of termination, on issues of illegality, a major area. Actually, one of the experts is our dear Professor Alexander Look, but I can't ask him to address us twice. He already given us a wonderful presentation in economic duress. For me, his presentation sets a benchmark for all of us academicians, for its analytical rigor, for its theoretical acumen, for its sensitivity to practical issues. All this is our challenge if we are to be academicians respected by our stakeholders. One of the objectives I have as someone who returned back to my alma mater, the Faculty of Law, is that my fellow colleagues in the academia will bravely face the stakeholders outside and do not be afraid to be challenged, to be criticized, and that we would refine our views and sharpen, as Oliver Wendell Holmes so rightly put in a wonderful anecdote. He says that common law jurists are like a pair of scissors. We sharpen each other up when we permit ourselves to be intellectually challenged and honestly wrestle with doctrines, theory, and practice. The brave new world of 21st century is not only coming at us, we are already there. And much of what we have hinted of in shades and in colors the last 3 webinars alerts all of us that the study of law, as our dean has reminded us, quoting from that great jurist called John Austin, is an exacting art and science. It requires devotion, commitment, exegetical rigor of both doctrines and practice. And today, as we conclude the session, we are aware that law straddles the community, the consumer. It has interface with economics, risk allocation. It has interface with the credit and security system, whereby we cannot unravel a thread without threatening the whole fabric. There are many challenges indeed. Our journey is only just begun. And I thank all and sundry here, including former alumni of Universiti Malaya who has joined us. Of course, Dr. May Chong, who has given us an abiding interest in contract law by her textbook, which we hope she will update soon, and her remedies. Puan Chong, who has stayed on with us and shared her views on LAD. Usha, who is still here. Dr. Uzura, who has moderated, and others who I have left out, but not intentionally. Dr. Majid, my great eminence, who migrated from English literature to commercial law, whereas I went the other way around and trying to teach literature now. So we are all learning from each other. There is so much promise and excitement in all our life, isn't it? And we welcome it and embrace it. We thank all of you, and I hope that what we have done these 3 days is just the beginning. I hope to pursue this reform initiative with relevant authorities, and Anand has already want to escalate it by setting up a subcommittee in the bar on law reform of contract. Perhaps we can throw consumer law into for Dr. Ong Si Chin to put her teeth on. We will see how the journey goes. But we begin, as the good book says in the book of Ecclesiastes, we cast the bread on the water. Perhaps it will come back to us. Thank you all for your journey with us. Thank you for staying alongside with this webinar. And thank you, staff and colleagues of Universiti Malaya and those who joined us from outside, contributing their knowledge, and in the chat, bringing us updated articles. Thank you, Cheryl, for that, and others who draw attention to it, Dr. Tan, and those who has listened in. For tonight then, I bid you good night. Watch out for other webinars. Forthcoming this weekend is our constitutional law crisis and challenges. We have 3 major webinars. We have learned jurists like Andrew Harding and Kevin Tan. We have others locally contributing to the whole area of contract law and crisis, constitutional law, sorry, and crisis. From private law to public law. Why not? All of law is part of our journey intellectually and professionally. So good night and thank you and God bless.
Thank you.